from NFIB Pennsylvania, and now I'm going to turn it over to Elizabeth Milito, who is from our Legal Center. Beth, go right ahead.
Thank you so much, Suzanne, and thank you everyone who is tuned in today for this webinar on sick leave issues. This is being recorded today. So if you know, I think Suzanne's going to make it available if anybody wants to forward it on, or if you missed anything or need to leave early, that's perfectly fine. We are happy to take questions throughout today's presentation, and I think one of the last slides too is going to provide my email and my direct phone number. I work out of NFIB's Washington, D.C. office in the NFIB Small Business Legal Center, and please know I'm always happy to take calls from members. If I don't know the answer, I'm happy to help try to find an answer for you or refer you to somebody who can. So please know that we're happy to take questions both in the Small Business Legal Center, and then also the folks in the Pennsylvania NFIB office are very helpful too and a great resource. So today's webinar, we're going to talk about primarily workers' compensation, the Americans with Disabilities Act. Let me flip to the first slide here, and then finally touch briefly on the Family and Medical Leave Act. And then run through a couple, hypotheticals. These are all taken, the hypos I have are taken from real questions that I've gotten from NFIB members. So let's start here. So we've got this alphabet soup, as is often the case in human resources and employment law area, the WC, ADA, and FMLA. And as I said before, it's Workers' Compensation, Americans with Disabilities Act, and the Family Medical Leave Act. Those are three laws that apply to some or all employers, depending on your size. And there can be crossover and overlapping issues that come into play when you have an employee who is out on leave or is sick. And it's a very frequent question I get from members. I talk to probably on average 2 to 3 members a day here in the Legal Center via email or phone call, and I would say on average there's probably about 1 call a day at least that pertains to a sick leave issue. And the question that comes up most frequently, I really think, is can you terminate an employee who is on workers' comp? I get this time and time again, and I know it's a frustration for small business owners because there's not a clear answer, but hopefully what we go through today will help you work it out and at least give you some resources and some direction when dealing with an employee who's just kind of out on leave and floating around out there, kind of in this Bermuda Triangle. So here we are. Why are we here? First of all, let me start by saying that there is no, as of right now, there is no Pennsylvania labor law that requires an employer to provide sick leave, paid or unpaid. Many employers do that or have paid time off plans that an employee can use for either sick leave or for whatever leave purpose they want. That said, while there's no federal or state law that requires sick leave, there may be requirements to provide unpaid leave under workers' compensation, the state law, the Americans with Disabilities Act, or the Family Medical Leave Act. So there may be obligations to provide some type of leave, unpaid leave. So you want to find out what laws apply to you and an employee who may be out with an illness or a disability or a work-related injury. So let's start with the workers' compensation law. Again, this is the one, the law I hear about the most frustration from NFIB members, and it's simply because in Pennsylvania, as in most states, or majority of states anyway, workers' compensation applies if you have just one employee. So the requirement in Pennsylvania is that you provide workers' compensation if you have just one employee. And workers' compensation provides for medical and wage loss, and it's without fault. And the trade-off is that the employee then cannot sue you for, the injury or the illness that they may have suffered while working on the job. So it provides protection from lawsuits filed by injured employees. And it covers the on-the-job injury, Pre-existing injuries too, and I know again this can be very frustrating because you have really no control over what sort of injury or even illness an employee might be coming to you with, but that's just part of the public policy trade-off, if you will. It's, you know, the protection that's provided is that you may not be on the hook for the full amount and the employee cannot sue you. But that said, if the employee aggravates a pre-existing injury, they would be entitled to workers' comp. One question, and I put this last bullet here because this actually came up last week. A member called me, an employee was in a rather serious car accident while on a lunch break, and it was an unpaid lunch break. They were gone for an hour and not doing any sort of work-related duty, running personal errands. I think running to a Target or something. So the question came up, and not in a company vehicle either. They were in their personal vehicle too. And the question was, is this something I should report to, you know, my workers' comp carrier? Generally, if the employee is on a personal lunch break, it would not be, unless they're doing, you know, an errand for the employer, for the business, it would not be, at least under Pennsylvania law, eligible for workers' comp. And that's the case in most states too. Other things that would not be covered by workers' comp, intentionally self-inflicted intoxication. This was something else I heard from a member, somebody who was drunk, was in, again, a car accident issue. Again, that would not be covered by workers' comp. And then injuries caused by breaking the law. So if the employee is doing something illegal. But if it's just negligence, you know, they weren't being careful, those are the sort of things that workers' comp does cover and is intended to cover. Okay. The exclusive remedy, again, this goes back to the employee can't sue you if they're hurt on the job. So it is providing business owners some protection. You can only file also for lost wages and medical bills, pain and suffering under workers' comp. You know, like a personal injury claim as a result of a car accident, you can recover for pain and suffering. Workers' comp, there's no pain and suffering available. It's just the medical bills and lost wages. And Pennsylvania, as in most states, it's roughly 2/3 of lost wages. It can vary. There's 2 exceptions to this exclusive remedy. If the injury or illness was caused by a defective product. So the defective product is, you know, there's a ladder that was defective, a new ladder you purchased for your business, it's defective, employee climbs up on it, it collapses on them. In that instance, the employee might be able to file a lawsuit against the manufacturer. So again, it's not necessarily going to be against you, the employer, but they probably would be able to assert, if it was truly a defective product, assert a claim against the manufacturer of the defective product. The second bullet there, number 2, if a coworker assaults the employee based on a personal matter. And I just read a lawsuit where an employee was denied workers' comp benefits. Fight broke out on the plant floor between 2 gentlemen. Maybe they weren't gentlemen actually, because they were gotten to fight over a woman. And they were both pretty seriously injured, but the workers' comp claim was denied on the part of both the employees too, because it was resulted as a personal matter, not work-related at all. So in that case, the employees could not only not sue the employer, but they also were not entitled to workers' comp for their injuries and for their time off from work. So the next slide here is probably amongst the most important things to consider when it comes to workers' comp, besides having coverage and ensuring that you maintain coverage. Because I didn't put a slide up on this, but as you're probably all aware, the penalties for not carrying workers' comp coverage in Pennsylvania, as in most states, are pretty steep. And there's even a possibility for criminal penalties, criminal prosecution too. I think it's more likely you see civil fines and penalties because the injured employee would have to be paid out of a state pot of money. So the state's going to come back against you for that money. In addition, they would subject you to fines. So you want to make sure you are carrying workers' comp at all times, that there is not a lapse in your coverage, because, you know, Murphy's Law, that's when somebody's going to get hurt or slice their hand open. So make sure there's no lapse in coverage. One other note, too, about coverage. In Pennsylvania, because you can go to private carriers for coverage, it does and can pay to shop around. And in fact, I think on Pennsylvania's L&I website, I even noticed that, that the state put that on there too, that it's worth, you know, shopping around, so to speak, calling around to different carriers too, to make sure you're getting the best rate possible and to make sure that you have all the coverage that you need. So that can pay off. So when it comes to reporting injuries, this is very important that you make clear to your employees and let your employees know that if there's anything that happens, any injury that happens during the workday, on the job, or anything related to work, that they report it immediately. Delay in reporting claims can really raise the cost for settling the claims. I've seen, waiting almost a week can raise settlement costs by 50%. The bottom line is you want employees to come to you as soon as possible, as soon as they're aware, they get home and, gee, oh my gosh, I think I put my back out today lifting all that, lifting that stuff off the truck. I mean, they need to call you or, come to you the next morning and report the injury. Don't wait. And then you need to immediately notify your carrier. That's really important. The Pennsylvania Workers' Comp statute requires that claims be reported no later than 120 days. And also indicates that, in fact, claims should be reported within 21 days. But you want to notify the carrier ASAP, and employers should be notifying you, the employer, ASAP. That's very important. You also need to submit the first report of injury electronically. And the report is available on the Pennsylvania website, too, and I think we have the link for that on upcoming slide. So reporting injuries as soon as possible, very important. Yes, here it is. The website is right there. There is a handbook on there for employers that gives some additional information on the Pennsylvania Workers' Comp. There's a number that you can call to, an employer services hotline number, which employers, so it's employers only. The bottom line is, if you have questions, if you have any suspicion that there may, an injury, an employee's injury might be work-related, call your carrier, report it.
Now, Beth, I was going to say, yeah, all these phone numbers, we will definitely offer the recording of this and put it on our YouTube and our Pennsylvania website, so they don't have to jot down all these numbers.
Oh, right. Okay? Perfect. Thank you so much for saying that. Yeah, because there are a lot of numbers here. I think the main one there to keep note of is the Employer Services Helpline. Of course, you can always call the Pennsylvania NFIB office or call me here at NFIB, but it's nice that Pennsylvania actually has a dedicated employer helpline for questions. But your carrier can also be a great resource, too. And again, just kind of a side note, too, I talked with a member last week, not in Pennsylvania, but also in a state where you're to immediately report claims and with private carriers, so it's not a state-run workers' comp system, too. An employee was burned at work. And the employer did the right thing. He drove the employee to, an urgent care clinic, bandaged the employee up, but he didn't report it to neither the employer nor the employee reported it to the carrier. The next day, the employee called up, and the burn was actually much worse, and he ended up going to the emergency room. The employer paid for that, too, came and met the employee at the emergency room, covered all the medical care. But anyway, there was a week delay in reporting it to the carrier, and the business owner called me, and he said, at this point, the carrier has really worked with me, but he said, I did get chastised and reprimanded for not calling and reporting it sooner, because what has happened now is the employee now has retained an attorney, has not returned yet to work, even though I think a light-duty position could be. It just gets a lot more complicated, whereas I think if the carrier had been able to step in and let the employee know all the resources that were available, it may have forestalled the employee from running off to an attorney. And that's really what you want to. You want to get the employee back to work. You want to get them better. You want to make sure they're getting the medical treatment they need. And the carriers can really be helpful in making sure that is done. And also, again, reassuring the employee that their best interest is at heart. So understand, okay, so I want to focus there on the second bullet there. Do not retaliate against an employee because they filed a workers' comp claim. And again, this goes back to the question that I get asked the most here at NFIB. Can I fire Joe because he's been out on workers' comp for 6 months? I mean, what am I supposed to do? So let me start by saying that Pennsylvania, as in most states, 49 out of the 50 states anyway, and also the District of Columbia, is an employment at will state. So in theory, you can terminate an employee for any reason, no reason at all, as long as it's not a discriminatory reason. So that last phrase there, as long as it's not for discrimination or retaliation, you can terminate an employee. So workers' compensation laws do protect employees from retaliation, by and large. So that means you cannot terminate an employee because they filed a workers' compensation claim. So that's where it gets tricky. So can you fire an employee who's been out on workers' comp? My response is, in general, it's not a good idea, because in many states, and in Pennsylvania this is the case too, there is going to be a presumption that the termination is in retaliation for filing the comp claim. So you can do it, but you must do it very carefully, and it cannot be because the employee filed a workers' comp claim. So how do you minimize liability? First of all, be proactive in safety training. Again, report those claims immediately. Get your insured app, make sure the employee is getting the medical treatment they need. Maintain a drug-free workplace. I talked about the employee who was, was in the accident because they were drunk. I mean, you want to let your employees know that sort of behavior is not going to be tolerated. It's a terminable offense, regardless of whether they're doing work stuff or not. Again, that sort of behavior is not going, it's illegal if they're using illicit drugs, and if they're drunk, they're violating the drug-free workplace policy. So that's not going to be, anything that's going to be covered by workers' comp. And then commit to return to work. You want to get everybody well and back to work. And you want to make sure your employees are aware of your commitment to get them back to work. Send a job description to the physician if you're in contact, or make sure your carrier is in contact with a physician and they have a job description. Where possible, get them back on a light duty assignment. And I appreciate for many NFIB members, small business owners, this is not possible. You can't just create a light position. Any position you have is integral to your business. So it's not always possible. But some larger small businesses can do a light duty. Because again, getting the employee back in the business, that's the first step to then getting them back to their other job. And finally, do not terminate without consulting an attorney and or the carrier too. Be very careful about doing that if the employee has not reached, been released or reached maximum medical improvement. Okay, and so why don't you want to terminate? This leads into obligations under the Americans with Disabilities Act. Sometimes an injury, a workers' comp injury, let's go back to Joe with a back injury there, it can morph into what is a disability. So employers under the ADA, the Americans with Disabilities Act, are required to reasonably accommodate qualified applicants and employees with disabilities unless it imposes an undue hardship. So there's really 4 components to the ADA law. I want to mention, too, that Pennsylvania has its own disability law. So, and this law applies to any business with 4 or more employees. So even in, smaller businesses really have an obligation to, when they can, accommodate employees with a disability. But the accommodation, here's the disability. So the disability substantially limits a major life activity. And again, that would, I heard somebody say to me, somebody said to me recently too that we are all really just temporarily able-bodied. Eventually, probably all of us are going to have some sort of, ailment or something that qualifies as a disability. So the real focus, I think, for businesses and employers is focusing on, so assuming somebody has a disability, Joe with a back injury, let's focus on whether or not there is an accommodation we can offer Joe that will allow him to perform the essential functions of the job. Because it may be that there's not a way to accommodate Joe. Joe is a warehouse worker. His job requires him to lift at least 75 pounds. So, and you don't have a light duty job for the warehouse workers. And Joe, there's no office job for Joe. So in that instance, you may not be able to accommodate Joe. Joe may have to, apply for disability or look for a job, move into some, company where he can do an administrative job. But in other instances, there are ways that you can restructure a job. An employer can restructure a job and provide a reasonable accommodation that will allow the employee to perform the essential functions of a position. The undue hardship, again, this is defense for the employers that you just cannot offer the accommodation requested is just too expensive or just can't be done. And small businesses, again, are going to have different obligations and different duties than a larger business. A jury and a judge is not going to demand the same of a small businesses. And it's a fact-specific inquiry, but that is not necessarily a bad thing when it comes to a small business. So the disability law recap, the plaintiff must show that they're disabled, that they're otherwise qualified to do the job, and the employer could but did not make a reasonable accommodation. So the reasonable accommodation, that last number 3 there, know that in some instances a reasonable accommodation might mean giving a little bit additional leave time off, unpaid leave time off, another 2 weeks to recover to get them back. But it's reasonable accommodation, it's not capitulation on the part of the employer. So there's going to come a point where the employee is going to need to come back to work and is going to have to be able to perform the essential functions of the job. And if the employee is not able to do that, that's when the employee needs to look for employment elsewhere, job retraining, maybe through, if it was a workers' comp injury, job retraining, or potentially, disability, long-term disability. So again, it's just reasonable accommodation, not capitulation. So they can't go on indefinite leave. That would not be reasonable. A court would not find that to be reasonable. Yes,
Beth, if I could just quickly say, we've not had any questions, and you've covered a lot of great material, but I just want people to know that they can type their questions in, and I will throw them at you as we go along if they choose to. So go right ahead.
Okay, great. Thank you. So the last law that I wanted to touch on today is the Family Medical Leave Act, the FMLA. This is a federal law, and it applies to employers with 50 or more employees within a 75-mile radius. So this law does not apply to a lot of NFIB members. By and large, I would say the average NFIB member has about 5 employees, 5 to 8 employees. So we probably have less than, I would say, 10,000 NFIB members for whom the FMLA is applicable. With that said, there's some of you out there today, or some of you might listen to this, that have 50 or more employees, in which case you do have obligations to provide 12 weeks of unpaid leave for a serious health condition. So this is a lot of times I think I've heard, hear from people, well, isn't this just for women when they have babies? No, it's for the employee's own serious health condition too. So recovering from surgery, taking care also of a family member, a child, or a spouse that's had, needs time off for a medical condition. And FMLA leave can also be intermittent. So somebody who needs to go to dialysis, every week or every other week. If they work for, if they work for a qualified employer, in other words, an employer with 50 or more employees, then they would be entitled to intermittent leave, time off, every week to go to dialysis. I'm going to skip over this here. Just know this slide is here. If the FMLA is subject to your business.
Can I ask a quick question just out of curiosity? Sure. When it says family members, would that be caring for an elderly parent as well?
It's children and spouses. So,
okay.
But that said, Suzanne, I do know, yes, immediate, but I do know that some businesses, and this is certainly something, even if, and I should back up and say too, that even if your business is not subject to one of these laws, the federal, the Family Medical Leave Act too, I do know certainly that many small businesses are very generous with leave policies and would certainly, entertain a request from an employee. I've talked with business owners, and I'm sure you know this to be true too, Suzanne. So, even if you're not subject to the Family Medical Leave Act, I know that, there are many businesses out there that do offer, very generous leave policies and do what they can to work with employees who, are in a situation, like you said, who need to take time off to care for an elderly family, you know what I mean, a parent, a sibling, something like that.
All right, now we have a question, if I could throw it at you, please.
Sure.
If someone lived in another state and filed and was receiving workman's compensation from that state, and then they moved to Pennsylvania, could they get a job in Pennsylvania and still collect workers' compensation from the other state? And then they get injured in a job in PA, can they claim workers' compensation for PA as well?
Okay, so first of all, let me take part one of the question, because that's a great question. Okay, one of the things that when I was studying the Pennsylvania L&I website too, there is a very nice section on there about reporting suspected fraud. And this is true in most states too. The state wants to know if there's suspicion that somebody is collecting workers' comp and employed, and also collecting a paycheck. So the bottom line is that is a situation where I would encourage the business to report if they get wind of that going on. So, it's the same thing with unemployment too, right? If somebody's working under the table, collecting, a paycheck, if you will, under the table, and also collecting unemployment. I mean, they're double dipping, right?
So basically, it appears that something like that would be fraudulent, but go ahead and report it and let the state work it out.
Exactly, yes. So I would encourage the business to report that situation, because I don't think you should, most states would prohibit, doling out workers' comp while the employee was working, whether in their state or another state. They don't want that to happen.
Okay.
With regards to the subsequent injury, if they worked in Pennsylvania, then yes, they could collect in Pennsylvania. And this is where you may have, the aggravation of a pre-existing injury there. One thing I didn't touch upon, and I should mention this too, with regards to workers' comp, I know this goes back to kind of hiring do's and don'ts. I know one of the questions most employers would really like to ask an applicant is, have you ever filed a claim for workers' comp, right? I do not recommend asking that question, because if you do not hire the employee, what's it going to look like? It's going to look like you didn't hire them because they filed a workers' comp claim, and that would be, again, fall under that retaliation prohibition in the workers' comp statute. So unfortunately, that's not a question you can ask. But what you can and should ask employees, particularly if it's positions, again, going back to Joe in the warehouse, it's a position that's going to demand, physical exertion. In an interview, you want to make sure the applicant is aware of everything that the position is going to require. Lifting 75 pounds 100 times a day, unloading the tractor trailers in the back, everything that the position is going to require, let the employee know. Have them sign off on a position description, attesting to the fact that they can perform all those essential functions of the job. And on the L&I website too, there is a very good fact sheet that talks about pre-employment testing too. So, whether it's physical testing or, an agility test, that sort of thing. There are ways you can do things like that to ensure that the employee can perform the essential functions of the job before you hire them. So to try to weed out people, who are just going to come in and then a week later claim they hurt their back, when in fact they've had, a back injury for 15 years and could never have performed the job.
Beth, forgive me here. We do have another question. Yeah. Would you like to finish the FMLA part before I ask it, or would you like to go to it right away?
You can go ahead.
Okay. If an employee has an open workers' comp case and is on light duty and now requesting an FMLA to care for his parent out of the U.S., what action do you recommend for that employer to do? So basically, we have an open workers' comp case. The person's on light duty. Now they're asking for family leave to care for a parent who's not even in the United States. What would you recommend the employer do?
Okay, I would certainly like to talk to that business owner offline more, because that is a tricky thing, because the FMLA is not at all related to the workers' comp. So, but that said, I think the employee may be entitled to some FMLA leave, but I want to make sure that the employer, one, is subject to the FMLA, has 50 or more employees too. And then I think you also would need to coordinate, if they're on a light duty position, coordinate with a carrier too to ensure that maximum medical improvement has not been reached or is not going to be reached soon. Which
okay, well, that's complicated. So
yeah.
What we'll do is when we get near the end, we have your phone number and contact information. And the other thing, we'll, again, publish the slides and send them out to those who've participated. So let's move on, and I'll let you know if there are any more questions.
Okay, great. Thank you. So finishing up here, the FMLA leave. And then this is just a recap here, a little graphic showing the three things. The ADA prohibits discrimination against a qualified individual with a disability, but also know, too, that you cannot discriminate against somebody because they file a workers' comp claim. You know, terminate somebody because they file a workers' comp claim. So you really need to be, there are ways that you can terminate an employee who is on workers' comp. You know, you're doing a layoff. That position was slated to be terminated anyway, you know, discontinued anyway. This is a very common one. There was documented history of poor performance by the employee right before they got hurt. And that's, I think that's pretty common too. An employee knows the hatchet's coming and, you know, all of a sudden comes up with a work-related injury. So that's why it's so important to be documenting poor performance or behavior issues before something happens like a workers' comp injury, because if you've got it documented, you've justified the employee's termination before the workers' comp injury. So there, you can go ahead and terminate the employee, because the termination, you can show the termination is not because they filed a workers' comp injury, it's because they were doing a really bad job for the last year and was messing stuff up. And then finally the FMLA. Yes, Suzanne.
I was just going to say, we did get quite a number of attendees who came on very late, and the numbers increased who are on the phone, and I just wondered if you could just recap some of the material right at the beginning that related to workers' compensation that you felt were the most critical, since we do have some newcomers, just the main highlights, because it looks as though you're getting near the end.
Okay, yeah, sure, absolutely. So let me go back and back up then again, is talking about workers' compensation. And the question, I'll start off by saying that the question I get here at the Small Business Legal Center and talking with members who have employees who are sick or hurt most often is, how long do I have to keep the position open? How long do I have to, you know, accommodate this individual, or how long can they be out? What can I do? So most employees have at-will employment, meaning their employers can terminate their employees for any reason or no reason whatsoever. Similarly, of course, that means that employees can quit their jobs for any reason or no reason. So most of your employees out there are going to be at-will employees. But if you have an employee who's filed a workers' comp claim, you want to be very careful about terminating them if they have an open workers' comp claim, because an employer cannot terminate employment in retaliation for filing a workers' comp claim. So again, be very careful. I will say be very careful. Again, if you've documented poor performance before, if there's a history of, you know, misconduct and you've documented it, and then a workers' comp claim happens, but you were actually planning to kind of terminate, you were planning to terminate them anyway, then you can go ahead and, you know, terminate the individual, because you've got the evidence to show the termination was not because they fell off the ladder. The termination was because they were getting in fights, they weren't showing up, they weren't doing the work, that sort of thing.
But you would advise that they do consult an attorney, was that correct? Did I see that?
Yes, consult an attorney, yes, consult an attorney and or consult a carrier too. I think it's very important to do that, and you know, get the advice of the carrier. I think this is where working with a carrier when you have an employee who's out on workers' comp or has returned to light duty too, because that's another thing too. You know, they're on light duty, and I certainly hear that from business owners too. You know, she's been on light duty for, however long. And I really need her to be able to, go back out in the warehouse, and I can't have her, sitting at the desk all the time anymore. When is it? And that's where I think you really need to push the carrier to release the employee, maximum medical improvements and really, reach. And at that point, the employee, you can terminate the employee because you can't do light duty long term. This has to go back to, full-time warehouse job. We offered you light duty, but this is just a temporary, it was a temporary, we can't do this indefinitely. So working with a carrier and consulting with a carrier and or an attorney before terminating somebody who is, has an open workers' comp case, I think is very important. And then understanding too.
Yeah, go ahead. I wanted to ask one more question and encourage anyone who's on the line, because it looks like we're nearing the end, if you have any questions, to please type them in and we will get them answered. But I'm going to throw one at you because I remember an experience in a prior job I had where there was an employee who had mental issues and made it very difficult for all the employees to work with that person. But I know there's some cases in Pennsylvania where mental issues have been considered, does that fall under the ADA, and in what capacity?
Yes, and that most definitely would fall under the ADA. So any, mental and physical disability would fall under the ADA. And there may be an obligation on the part of the employer to accommodate the employee if the employer can do so without an undue hardship. So again, there are certainly instances where the employer is not going to be able to accommodate the individual. And, I always go back to, I've heard this, well, I can't come to work because my supervisor stresses me out, and I have stress, I have depression. Well, depression can, in fact, be, a disability. But a business can't accommodate somebody by saying, you don't have to come to work. You can just, I don't know, work from home, telecommute forever because your boss stresses you out. That's not a reasonable accommodation. So again, it's got to be reasonable. So there are certain instances, in situations where the employer is not going to be able to accommodate the employee, and the employee, termination would be appropriate. Let me see. I just want to, because we are coming up on the end of the time too. Again, the termination here. So this kind of gets to the question you just asked there, Suzanne. Somebody with a mental issue who just, I can't come to work, or, I'm not going to know if I can come to work. It depends on how I feel when I wake up in the morning. So can you give me, a flexible schedule? If I feel okay, I'll come in. If I don't feel okay, I won't come in. This first bullet here, that's from a real case too, an NFIB member actually. She asked if she could work from home. And I remember this instance too, the individual actually supervised somebody else. She was the office manager too. And that was not, a situation where I feel like a court would ever say, that's okay, Mr. Business Owner. You can, it's a reasonable accommodation to have her work from home, all the time. So while she does have probably a qualified disability, her reasonable accommodation request, I don't think would hold up. So leave for alcohol rehabilitation. If they are in recovery, that is a qualified disability. So a situation where, again, it's the unpaid leave. So if the business can do so, if it would not be an undue hardship to offer, unpaid leave for 30 days, then that would be appropriate. The first bullet there relates to a workers' comp, permanent and potentially disability law too, because it's a permanent shoulder injury. So that would likely be, a serious medical condition that would fall under the ADA. She can't perform her job, however, without help from other employees. So the new equipment, well, buying a table is probably something, a business might be able to afford, but to have another employee assist this employee with her job full-time, that's really not likely to be found to be reasonable, because essentially you have two employees then doing one position. Again, this is something where the employee probably on her own will need to, look into job retraining or finding something else or applying for permanent disability. And then the last one there, I was using Joe before, but we've got Brenda who's been out on workers' comp for 2 months for a back injury. She doesn't show up for work on Monday, so can I terminate her? She's, as far as I know, she was released, and I actually, have a light duty position she can do for a couple months, but she doesn't show up on Monday. Can I terminate her? Again, the documentation is important. Check with your carrier or an attorney, but if she's been released and or has received, the maximum medical improvement, then ultimately, termination may be what needs to be done. You don't need to leave the positions open indefinitely, and courts have found that indefinite leave is not a reasonable accommodation. So I think employers should take some comfort with that, that the courts are, I think, by and large, have found, that particularly with smaller businesses too, they really look at the resources, and the decisions I've seen too, they really look at the resources of the employer and take into account too the size of the employer, the size of the business. So, what a small business can do is just not going to be the same as, what a larger employer can do, and courts do appreciate that. So again, the laws there, I have the last bullet there, again, going back to the point that some employers offer, fairly generous leave packages, either paid or unpaid, and that's perfectly fine, or do offer, short-term or long-term disability too. So that's something else that might be available to your employees if they do have, a non-work-related injury, and something that doesn't fall under workers' comp. My email's there, the phone number to reach me too, and then we also have several legal guides, including our Federal Employment Law Handbook, and that has inside a list of interview questions and just talk about, what you can or cannot ask when it comes to workers' comp or disability issues. I know, Suzanne, you have said you're going to make the recording, and I guess maybe the slides available too for members. Please don't hesitate to follow up with me if you have additional questions that we didn't get to. Is there anything else, Suzanne, that you wanted to ask or touch on?
Just the last thing, if you could go back 2 slides, there was something there under sick leave. What is PTO and STD? Okay, so PTO is paid time off. So some employers I know don't have, they don't distinguish between sick leave or vacation leave. They just offer, 5 days PTO, paid time off to their employees throughout the year. So, and then the short-term disability. I know some employers do offer short-term disability, or the employees on their own can buy short-term disability. So I apologize for not spelling out what those acronyms are. I know I've thrown a lot of alphabet soup at everyone. No worries. So, yeah. Well, listen, this has been marvelous, and I want to thank everyone who stayed on the call throughout, which I greatly appreciate, and any of you who joined late and anyone who wants the slides, I will put them on the nfib.com/PA website by this afternoon once I have the recording, at worst case tomorrow morning, and you can view them then. And also, why don't you just one more time review your phone number, Beth, and then we'll thank everyone for coming. Okay, so the number to reach me is 800-552-NFIB, and it's Beth Milito, and you can call anytime, email anytime. Thank you, folks. Really appreciate it. And any feedback you have, we'd be loving to hear. Take care. Bye-bye.